Equal Employment Opportunity Commission. What is the Equal Employment Opportunity Commission? The EEOC is an agency that enforces federal laws to make it illegal to discriminate against those applying for jobs as well as current employees. Most employers with at least 15 employees are covered by EEOC laws, 20 employees for age discrimination cases. These laws apply to hiring, firing, promotions, harassment, training, wages, and benefits. What type of discrimination cases does EEOC cover? The Equal Employment Opportunity Commission regulates laws that protect those in the workplace from different types of discrimination, such as age, gender, race, color, religion, sex, disability, as well as discrimination against those who filed a discrimination charge or are involved in a discrimination lawsuit. In the following slides, we will go over some types of workplace discrimination in more detail. Genetic information discrimination. Genetic information is defined as information about one's genetic test and history, as well as genetic tests and history of one's family. Title II of the Genetic Information Non-Discrimination Act of 2008, which was enforced in November of 2009, protects applicants and employees from genetic discrimination. An example of genetic discrimination would be not hiring a qualifying applicant because they have diabetes. Age discrimination. Age discrimination is when an applicant or employee is treated differently because of their age. Discrimination towards someone's age, for example, could be lower wages because of age, or being passed up for a promotion strictly because of someone's age. Harassment about someone's age can include derogatory remarks regarding their age. National origin discrimination. National origin discrimination occurs when applicants or employees are treated differently because they are from a different country, have a different accent, or appear to be of a certain ethnic background, even if they are not. This type of discrimination can also occur when the victim is married to a person from another country. It is possible for the victim and harasser to be of the same national origin. For example, an employer can only require an employee to speak English if it is required for the job. To enforce an English-only rule is only lawful if required for the safe and efficient operation of the business and not enforced for discriminatory reasons. Disability discrimination. Disability discrimination happens when an applicant or employee covered under the Americans with Disabilities Act or the Rehabilitation Act is treated unfairly because of their disability. This also includes those with a history of disabilities. The law also protects those with relationships of those who are disabled, for example, a disabled spouse or child. Harassment. Harassment in the workplace can consist of offensive slurs or jokes, unwelcome conduct of any kind, and is considered harassment when it creates a hostile, intimidating, and abusive work environment. Harassment is also unlawful when enduring the offensive conduct is a condition of continued employment. The harasser can be the victim's employer, a supervisor in another area, agent of the employer, coworker, and even a non-employee. Pregnancy discrimination. Pregnancy discrimination is when a woman, either an applicant or employee, is treated unfairly due to pregnancy, childbirth, or a medical condition that is related to pregnancy or childbirth. If a woman is unable to temporarily work due to pregnancy or childbirth, her employer must treat her with the same fairness they would treat any other temporarily disabled employee. An example would be providing light duty or unpaid temporary leave if such is provided to other temporarily disabled employees. Race discrimination. Race or color discrimination in the workplace occurs when an applicant or employee is treated unfairly because he or she is a certain race or possesses characteristics of a certain race. These characteristics can include hair texture, skin color, or certain facial features. Someone can also be a victim of racial discrimination if they are married to a person of a certain race. Religious discrimination. Religious discrimination is when an employer treats an applicant or employee unfavorably due to his or her religious beliefs. The law protects not only those of traditional religious beliefs such as Christianity, Buddhism, Hinduism, and Islam, but also applies to those who have sincerely held religious, moral, and ethical beliefs. An example of religious discrimination is assigning an employee to a position of no customer contact because of actual or feared customer preference. Retaliation. The laws of the EEO do not allow for employers to retaliate against employees who act against employment discrimination, whether it be filing a claim or being involved in an employment discrimination lawsuit. For example, it is unlawful to retaliate against employees for the following: filing or being witness to an EEO charge, complaint, investigation, or lawsuit, refusing to follow orders that would result in discrimination, communicating with a supervisor about employment discrimination, or answering questions during an employer investigation of alleged harassment. Sex-based discrimination. Sex-based discrimination in the workplace is when someone is treated unfairly based on their gender, gender identity, or sexual orientation. The aspects of someone's sex can be discriminated against when in terms of work-based decisions. Sexual harassment. Sexual harassment occurs when a person is unlawfully harassed because of their sex. Sexual harassment can include unwelcome sexual advances, requests for sexual favors, and other verbal or physical harassment of a sexual nature. Both victim and harasser can either be man and woman or of the same sex. The following workplace laws are not enforced by the Equal Employment Opportunity Commission.